Hello all, my name is Sarah Britt and I am a Senior Data Project Manager at ICPSR. I work on the Health and Medical Care Archive, or HIMCA. It's the dedicated archive of the Robert Wood Johnson Foundation, which is sponsoring today's webinar. HIMCA has over 300 free data sets on healthcare, health attitudes and opinions, and series data for everyone to explore, and we recently created a law and policy class of. We'll post a link to our website in the chat. Today, we're here to learn more about the tenant right to counsel law and policy from 2017 to 2024 data. Professor Emily Benfer from George Washington University Law School and Jamila Michener from Cornell University Brooks School of Public Policy will be presenting. Thank you so much for attending. Emily, would you like to take it away?
Thank you so much for the opportunity to talk about this research. I'm delighted to be here with everyone and Jamila Michener, my co-PI on this project, to talk about our study examining tenant right to counsel, both law and praxis. So first I want to let you know about who we're working with today, so we can go ahead and start on the next slide. So our full study team in designing this research project included myself, Peter Hepburn from Princeton Eviction Lab and Rutgers University, Jamila Michener, who's here with us today from Cornell University School of Policy, actually School of Government, and Danya Keene from Yale School of Public Health. And together we designed a mixed method study to really understand what does tenant right to counsel policy look like, both in its design in legislation as well as in implementation, what happens to actually effectuate the policy. Next slide. So you've received a link in anticipation of this presentation to our descriptive analysis paper. So our first publication was a descriptive analysis of this tenant right to counsel law and praxis. And we also published in this forum a data set capturing 62 indicators across jurisdictions. It turns out that right to counsel policy across the country is very diverse and unique. And so we employed legal epidemiology to examine this right to counsel policy. And our mixed methods study included both policy surveillance and qualitative methods for both validation and understanding the effects of policies in practice. And with the help of a tenant advisory board that included tenants representative of almost all the right to counsel jurisdictions, who had experience with the eviction system, we were able to design and examine multiple aspects of right to counsel. So our interdisciplinary team paired that legal epidemiology with interviews, qualitative interviews of tenants, policymakers, program administrators, housing advocates, and people who were charged with implementing the right to counsel policy in their jurisdictions to look at first the characteristics of right to counsel programs. So that's what you find in the data set and in this descriptive analysis. To second, examine the adoption and rollout, so the origin stories of right to counsel programs. And in that, we identified factors that both inhibit and enable successful and equitable implementation. Third, we were sought to identify the potential and the pitfalls of these programs, including their impact on tenant well-being and housing outcomes, and their impact on power building among tenants within marginalized or race class subjugated communities, which Jamila Michener led. And finally, we developed a framework and research priorities for assessing right to counsel programs across jurisdictions, and we outlined many of those recommendations in this descriptive analysis article. Next slide, please. And I'll just mention before I go into the study overview that the framework has already been used to examine the effects of right to counsel on birth outcomes, demonstrating a positive association among Hispanic and Latino mothers in one jurisdiction that had right to counsel in place. So we're hoping that the study itself can be used to understand the variations and how those variations affect different outcomes for tenants, landlords, and communities at large. So in terms of our study overview, here's the description that I had mentioned earlier, that we had this policy surveillance. So how do these policies differ from eligibility, covered proceedings, engagement of affected populations, funding sources, as well as the administering body, and all this is captured in the data set. And then the questions we were curious about with regard to adoption implementation included what prompted policymakers to adopt right to counsel, and what allowed for these programs to be implemented. And then with potentials and pitfalls, we were asking what are the bounds of right to counsel as a policy tool, and how does it shape tenant well-being and housing outcomes, or address or reinforce these power deficits and alienation? And then finally, that research framework, how could right to counsel actually be assessed? What outcomes should be measured? And what aspects can or cannot be evaluated with the available data? Next slide, please. So when we're thinking about the eviction system, one of the first things we did was step back and think about, what are the complexities of this system and where is right to counsel actually engaging? And when you engage in systems mapping with eviction generally, you see that this is not merely about the tenant misses the rent, the landlord files for an eviction, they recoup the property or they recoup the missed rent, that it's much more complicated than that, and that eviction itself is a driver of other systems at the same time. So I'm going to set that backdrop as we go into this, because it became very apparent how the entire system is affected by this one intervention as we went into the study itself. So first, next slide, please. Eviction drivers. So what drives the eviction system? Well, according to the eviction lab at Princeton University, a significant number of property owners use the eviction process as a rent collection tool, that it becomes this debtor court rather than a means of removing tenants for other reasons. And the court actually complies with that. It typically grants the landlord the amount requested without an inquiry into whether it is the actual amount owed, plus fees that are requested by the landlord. It's designed to be fast. The average hearing lasts about 1 minute and 44 seconds. Many tenants are evicted for small amounts of money, as little as $120. And once in court, 97% of tenants lack legal representation and have little to no understanding of their rights in that system or that process or defenses that might be available to them, while 84% of landlords have an attorney. Next slide, please. Landlords frequently use the court to control behavior and to remind tenants to pay the rent. This is also born out of the eviction lab research. Nearly a third of households facing evictions are filed against repeatedly at the same address, a practice known as serial eviction filing. Serial filing, like all of the eviction system, disproportionately affects Black households, with 14.7% of Black households compared to 9.7% of white households being subject to these repeat filings at the same address. No state law requires that a landlord comply with local and state housing code before filing an eviction. This gap allows for management strategies, extractive management strategies, that leave a property to fall into disrepair as a cost-saving measure. So it's cheaper to pay a fine than it is to address these major repair issues. And then finally, rent bonds, another thing that's happening within the eviction system. Over 24 states require a rent bond where the tenant must pay a set amount into the court in order to raise defenses or obtain a hearing. So at either the first or the appellate level. And then finally, and it's not on this graphic, but all of this results in a Scarlet E. So the moment the eviction is filed, it latches onto the family or the household and creates this Scarlet E that is typically an automatic bar from a new rental unit or in a safe and habitable unit. With that backdrop in mind, next slide. We wanted to know, sorry, you can't really see that. We wanted to know where right to counsel is finding itself within this system and what it actually triggers in the direction of the system, in its virtuousness or viciousness, and how it goes from there. So here's where we'll take that blurry slide off your screen here. Next slide. Here's where we found right to counsel. So currently, right to counsel was in 5 states, 19 cities, and 2 counties have legislatively adopted this intervention. And according to the National Coalition for the Civil Right to Counsel, over 80 additional counties and 11 states are actively considering it as an intervention to eviction, as a prevention measure. And so we think that this is an important measure to be taking a harder look at and to be studying, because it is one that policymakers are increasingly interested in learning about and adopting. So what actually makes this work, or what are the effects of it within the community? So why do legislators adopt right to counsel? Next slide. We looked at the reasons for introducing it. And in more than half of the jurisdictions, lawmakers cited the health consequences of evictions, broader benefits for the community, the housing crisis at large, and the need for a more fair and just process as justifications for adopting right to counsel. In some cases, they also mentioned the scale of the eviction crisis and historical inequalities that have led to it. So why did they do this? In 19 of the 23 jurisdictions in the study, the preambles described their objectives or reasonings for introducing it. And so this is some of the outcomes that we saw. Next slide, please. We also found that right to counsel programs increase tenant representation, but that not everyone is eligible for a lawyer. Across the 23 programs that we studied, 15 limited the right to counsel to tenants who met criteria defined by income level or household characteristics like the presence of a child. So you can see the variation there in the graphic. And all of these graphics are available and figures are available in the study that was linked in the chat in the housing policy debate article. Other jurisdictions also limited right to counsel to tenants in certain types of housing or certain types of cases that were filed in the court. The most common limitation among these programs is income. In many cases, cities have actually expanded programs and removed eligibility requirements to participation. For example, Louisville removed the limitation that offered right to counsel only to households with children and opened it up to all households. And there's other nuances like that when you take a look at the study itself. Next, we looked at the timing of access. So next slide. The eviction system typically begins with notice to a tenant before the case is filed. Then the landlord files the eviction case with the court. The tenant is given notice of the hearing. Then they attend the hearing. The court makes a decision, and then there's a judgment issued, and the sheriff executes the eviction. So it matters when in that process a lawyer is engaged with the tenant. We found that right to counsel programs varied when the tenants had access to the program. The most common approach is to require the appointment of counsel no later than that first appearance at court. So this is after it's filed. While in 7 jurisdictions, an attorney can help at any point during the eviction process, in multiple jurisdictions, a lawyer is only available at the filing or hearing stage. And attorneys can also bring affirmative cases, such as for an illegal lockout, record sealing after the case, rent bond cases, or rent board cases, or a fair housing claim. And that happens in 9 jurisdictions. With the exception of Washington, Minnesota, and Nebraska, no right to counsel legislation requires the court to actually appoint counsel to eligible tenants, no other jurisdictions. And nor does right to counsel legislation direct courts to postpone hearings to ensure that the tenant can obtain counsel. Many courts did take that upon themselves, though, and we'll talk about that in a moment based on our implementation observations. And then lastly, and this is notable, 14 jurisdictions allow right to counsel attorneys to handle appeals of an adverse decision, which will be important in a moment and we'll explain momentarily. Next slide, please. And I'm going to hand it over to Jamila to talk about this in a little greater detail. Jamila, would you like to take this slide?
Sure, I'll jump in and
Thank you.
also say, Emily, please jump back in anytime I forget something important because that happens sometimes. Hi, everybody. Happy to kind of dig in here and kind of talk through some of the things that we learned from this, I think, really rich data resource that we're happy to be able to have others use and benefit from as well. So just in terms of the kind of outcomes that we attended to and were interested in, and especially, based on some of what Emily has already shared around kind of the policy contours and dynamics that we observe through our kind of legislative mapping and analysis across states and localities, we were thinking about whether and how those kinds of policy choices map to actual outcomes that matter for tenants and people on the ground, and how, right? And so we did a number of qualitative interviews and observations to help us try to start to assess what the implications are for outcomes and what kinds of outcomes are even at play here, right? And some of what we learned, some of what came to the fore is, just increased coordination among service providers and central intake sites. I mean, this is connected to increased outreach and education as well. making sure that people are aware of right to counsel once it's happened, once it's a, legislative and policy reality. The gap between that reality and people actually leveraging those services and opportunities was a broad one. And the legal services and legal providers themselves aren't always able to bridge that gap. And so the a level of coordination that is necessary among service providers of all different sorts and among the kind of central sites where people find themselves when they have these issues was really heightened once there was this resource that was available for people to be able to actually leverage. This connects with the kind of partnerships that were necessary to forge here between the kind of service providers and government entities that wanted to see right to counsel really significantly and meaningfully increase tenants' access to services that could help them avoid eviction and other harms. What are the partnerships that could be formed in order to make this feasible? And that required working with community and not against them. One of the reasons why we had a really robust tenant advisory board as a part of our research project was precisely because we wanted to make sure that we were doing this, right? And so similarly to what we tried to kind of model in our research process, we see this happening on the ground in a lot of these locales where partnerships are being catalyzed because there are now resources that are worth partnering around that weren't there before. I mentioned increased outreach and education along similar lines. We also wanted to think about the barriers to right to counsel. When does the legislative mapping and what we find on the books as far as policy diverge from what's actually happening on the implementation level? When are people not getting access? And what are the barriers that are accounting for this? And of course, how is this changing what's happening in courts and how courts operate? Because it's a large enough infusion of resources and change of policies and procedures that it's difficult to imagine courts simply operating as they were before. But the number and kinds of changes that could emerge were vast, and we were attentive to this. Next slide, please. So some of our preliminary findings, and we're actually working, we have the paper, of course, that we linked and that you all can read because it's published and we encourage you to, and we're working on follow-up work as well. And it helps to really underscore the possibilities in this data, and there are many. There are more papers to be written from drawing on the data than our team can write, right? So we're happy that people will be able to have access. But we have observed especially through some of the interview data, the shifts in court culture and practice, right? And we can even observe this in some of the filings and other kinds of data. This is particularly true and particularly relevant around habitability claims. And as Emily mentioned earlier, these were especially difficult claims to adjudicate. And they were the kinds of claims that often got lost in the mix with a focus on eviction, where whether landlords and property managers were actually doing what it was they were supposed to be doing around habitability was often not able to be adjudicated, in part because tenants don't always know that they should or can adjudicate that or how to. And having a counsel really changes the game for habitability claims. And of course, tenant case law, because now there are more cases that are actually being adjudicated, and some of those cases are able to set precedent and to change practices in ways that matter beyond the individual case, beyond the individual tenant, and that continue to have repercussions across entire local systems, court systems, right? Next slide, please. So just a few examples directly from our data that can help put a little meat on the bones, my apologies to the vegetarians, of some of these some of these broad findings that I've been referencing here. So what we hear from particularly the folks that are implementing right to counsel and that are in these courtrooms and that are seeing how what kinds of changes emerge that can compare sort of before right to counsel was a reality and after. So getting beyond the kind of policy enactment and the policy contours that Emily focused on to the real nitty-gritty nuts and bolts of implementation. And what is it that people are telling us? We focus here on what we're hearing from stakeholders that aren't tenants themselves, but I'll point out that we have a whole nother body of qualitative data that I've been, leading the way around collecting, where we do talk to tenants And we see complementarities, right? So these findings really extend across the folks who are experiencing and stakeholders in these domains. But one thing that was really common was sort of rubber stamp proceedings, and anybody who has spent time in one of these courts, you can watch a hearing unfold, and it's the blink of an eye, and there was no real adjudication, and somebody's in there and they're out, and there's barely been a moment to say a word, and they've lost their home, and their well-being is harmed. And that changes under a right to counsel context because there are more lawyers in the room who are there to represent tenants. And they're actually making arguments, legal arguments. They're actually offering legal justification. They're actually injecting case law in ways that just wasn't feasible for tenants to do. And it changes the kind of substance and the content. Oh, sorry, we moved forward a bit. It changes the substance and content of what's happening in the court as far as real adjudication, and how many of these evictions are substantively and meaningfully contested. Not just a rubber stamp process where you show up, oh, you're there, the landlord's there, maybe you're not even there, moving on, you get evicted. There's a real shift to adjudication, meaningful adjudication being much more common. Next slide, please. And of course, when it comes to habitability enforcement, we see that some of the kind of extractive practices that were happening before begin to be challenged, right? And a classic example of these extractive practices is, you're $150 behind on rent, and now you're in court getting evicted, but you're living in conditions that are blatantly illegal. There's mold, and there's unabated lead, and there's all sorts of harms that are being perpetrated through the habitability conditions that you're facing through your landlord. Your rent is not reflecting that, and you don't get any recourse for that, right? But now with a lawyer in the room, some of these both affirmative cases can be raised around habitability, and sometimes this can be raised as a way to kind of like provide more leverage in an eviction case. And in general, this practice that many landlords have of investing as little in the property as possible, and then being very harsh when and if they're not extracting the profit that they hoped to extract, that gets disrupted when a lawyer is present in the room who can introduce some of these habitability facts into the cases, and who can sometimes litigate affirmatively, right? In other words, not just being in a defensive posture as you are when you're being subjected to an eviction, but being in an offensive posture as you should be when the conditions of your living are not aligned with the legal obligations that landlords have to follow. Next slide, please. Another big thing that we see is practices around default judgments, right? And default judgments are actually quite common. Some of our interviews with stakeholders that I was able to do in default, there are in Detroit. It's astonishing the places where default judgments are extraordinarily common, and they come to be more of the exception than the norm. In many ways, this does not make sense, right? People don't want to just not show up and lose their homes, and have these processes move in a way that doesn't give them real opportunity to contest the harm that will befall themselves and their families. But the way that legal processes are built, especially when lawyers are not involved, in many ways, there's an inertia towards this is the current will carry you towards default judgments. And what we see is that when lawyers are present, there are fewer of these, and the cases are treated like cases, right? Not like something where you're just like, up, default judgment, move on. There's case law that is at play. And this notion that one attorney explained, it's basically because we treat every case like it's a death penalty case, right? Instead of thinking about eviction cases as just, okay, we're just going to move on. Let's get this done and move to the next. Really, they're being taken seriously in a way that is not possible, unfortunately, but true, is not possible when there isn't someone in the room to represent the interests of the tenant. Next slide, please. And, I think a big point that we're underscoring here, and I promise I'm getting close to the end. I know we're giving you all so much information, and it's valuable, but a lot to process. And we're looking forward to just answering questions and seeing if there are other things that you all want to learn about the data and about the findings. But one core thing that I want to underscore is the kind of systems change possibility that is inherent in providing people with this resource and of an attorney, and the ways that power imbalances, which are a fundamental part of legal processes like this. If I have a book coming out soon in January that's about people's experiences with civil legal systems, and we really focus a lot on housing. And I will be frank with you all, one of the reasons that I wrote the book is because I started to do research on right to counsel. And when right to counsel first happened in New York City in 2017, as a native New Yorker, I'm from Queens, so shout out to anyone else in the room from Queens. I was so excited as a native New Yorker who had interest in legal services and who had interned at a legal services corporation in college, and actually gotten so depressed by what I saw there that I changed my life plans. I thought I was going to be a lawyer. I wanted to represent low-income people. I did an actual internship where I got to shadow lawyers doing that. And I was deflated because the scale of the problem seemed out of sync with the scale and scope of the solution. I felt like so many people couldn't be helped through legal services. And so I did not choose that as a career, but I circled back to it as a researcher. And I really thought right to counsel is amazing. It'll allow us to help more people. But there was a skeptical part of my mind that thought right to counsel is an individualistic solution rather, to a systemic problem, right? It's about the rules of the game. It's not about just winning each individual case that comes before you. And actually, when I was doing the research for the book, one thing that would frustrate me, I would do long swaths of ethnographic observation in housing courts, sometimes for weeks on end, for hours a day, just watching. And I could see clear patterns in who was coming into that courtroom, Black and brown, low income women, in the problems that they were facing, in the treatment that they were enduring. And the judges never seemed to acknowledge that. They treated each case like its own individual thing. And that felt deeply unsatisfying. And in fact, in my book, I decided to focus on power and its importance in legal systems. And I became more skeptical as I went along of right to counsel. And one of the things I've valued about working on this project, first of all, that Emily Benfer was willing to invite someone on the project who had openly talked about and written about skepticisms and limits of right to counsel. And Emily knew that. And she said, we need this perspective. The other thing is that I had my skepticism not eliminated, but tempered. And it was tempered because we saw these systems changes, right? That actually having an attorney on your side gives you a source of power that you can leverage. It's not the only source. It's not the end all be all. And the power of the tenants themselves being built is really important. But this is one part of that larger process, right? So people having lawyers, is that all they need? No, people need more than a lawyer. They need actual power in our political and court systems that go beyond that. But that is a part of that. And once they have that power, one of the things that I find in some of my research, and that the principles of that are reflected in this research, is that there are spillovers, right? There are spillovers, and it begins to change the overall imbalance that is such an endemic part of what is happening in our civil courts. Next slide, please. So just around ongoing research, there's lots of work to be done. And I'll let Emily say more on this because if I'm honest, Emily Benfer is really the kind of heart and soul of this research. And she assembles incredible teams. I've been able to learn from so many of the people that I've worked with, and it's changed my perspective and my knowledge as a scholar. And there's so much more work to be done, including some work that our team is doing and more work that hopefully people on this call either can do or can benefit from, right? Whether it's thinking about expanding study sites and really learning about what's happening on the ground in these places, while that compares to places where there are no such interventions, what kinds of heterogeneity we can observe and see. We're embarking on a new project where we're really looking at settlements, And we're looking at the cases and using data around the cases themselves and the outcomes of the cases on the jurisdiction level. We're continuing to do and expand our qualitative interview research, our policy and policy mapping research. I mentioned observation. All this is a multi-method, kind of all hands on deck, all modes of research, including some more sophisticated quantitative analyses of difference and differences, where we can see a policy passes, we can look at what happens before and what happens after, and try to account for as many other factors as possible by leveraging timing. And that helps us to see to be able to make claims around causal effects on outcomes like case filing, right? And of course, there are additional members of our team like Nicole Summers and Rashida Phillips. This is really allowing us to leverage as much of the data that we've been and continue to collect to get both substantively interesting findings and implementable knowledge that's useful for folks that are doing this work on the ground. Maybe I'll stop there, Emily, and then you can jump in.
No, I really don't have anything to add. I think that was great. And I want to underscore what Jamila said about how the scale of the problem is out of sync with the solution. I think everyone on our research team is really curious and interested in identifying solutions that can evolve with the problem as it evolves and actually be a direct fit. So having this interdisciplinary team helps us to better define the problem statement, and digging into the research and the mixed methods, I think helps us flesh that out a little bit more too, so that we can identify what really works, and recognizing that the solution often shifts dependent upon the jurisdiction that it's in too, because every place that we visited has unique characteristics and traits, different advocates, different tenant-landlord relationships, different policymakers. And so taking the best of each of these and applying them as needed locally. And I'll just mention to talk a little bit more about what we're up to next with the right to counsel in shadow courts. Nicole Summers did a seminal study in Boston where she looked at eviction cases and coded the case files to understand what happens in this civil probation type agreement where tenants are subject to this shadow legal regime in which they can be removed from their house without substantive or procedural protections because they signed a settlement agreement that was not in their best interest, that they often didn't understand, and that can be enforced as soon as they miss a payment or whatever other obligation they agreed to. So she unpacked the case files and the settlement outcomes with that question in mind. What is this shadow legal regime? And so we're taking that model of case file analysis and coding, and we've multiplied across 12 to 14 jurisdictions. We're still expanding a little bit. And we're looking at about 1,600 case files per year per jurisdiction. And we're comparing at least 2 years before and after right to counsel, or in cases where there's no intervention, just 2 years, to see if there's a change over time. And we're pairing that with qualitative interviews. In our first study, we were really focused on people who implemented right to counsel, which typically the legislation dedicated funding to the legal aid organization or others within the city. Now we're expanding it to people who are touching right to counsel. So it's judges, landlords, their attorneys, court administrators, mediators who might be engaged, as well as tenants and their attorneys, so that we can get the whole scope and perspective of how this is playing out on the ground. And then we're also engaging in research of the court policies themselves. Many times, as Jamila mentioned, the court actually engaged in systems change because of the way they were seeing new light on these cases and what their role was in adjudicating. So how have they adopted policies that support that? We're also doing a court observation in at least one jurisdiction to see if anything changes on the ground and in real time. And then the eviction lab will be looking at the effect on case files. And you've already heard about the additional team members. I do want to mention that it's been really exciting to add PolicyLink because they have been engaged in a sprint across the country and working with tenants and tenant advocates on the ground. So having that perspective on the research and the different links in the community has been really eye-opening as well. So we're trying to continue to define the problem statement, expand it, and see what unfolds. The last thing I want to just add only because I've been looking at it recently, and I just think it's fascinating. So from the legal perspective on the team, Jamila talked about how we saw a shift from default judgment to tenant protective case law. That was due to the ability of lawyers in 17 jurisdictions to appeal outcomes that were adverse to their clients. These cases were not only setting precedent for that jurisdiction, in some places like Maryland or Minnesota, where the case was state level, it affected the entire state's eviction process, even if it was just in one jurisdiction where the initial case occurred. And these appellate decisions resulted in significant changes that affect all facets of the eviction system. So fundamental aspects of court proceedings, including when a court has a jurisdiction, when a default judgment can be ordered, when hearings must be postponed to ensure access to a lawyer. They also address things like notice requirement in federally assisted housing, the landlord's burden of proof. So no more could a landlord just state that there was an issue. They had to actually demonstrate it and abide by evidentiary standards in the court. And it also affirmed habitability defenses. And the courts even unpacked contractual matters, like when a tenant is able to consent to a settlement agreement and how much information and understanding they must demonstrate before the court can enforce it. So really addressing that shadow court issue as well. So the effects of right to counsel on the systems change aspect of this, and that giant map that we showed you at the outset of the presentation, was not something that I think we expected going into it. And it was really fascinating to find that this one intervention had such a dramatic impact on a system that had been functioning in a way that toppled pillars of resiliency and resulted in severe harm to millions of households across the country. So that we could find something that might shift that and create a more equitable system is really exciting, and something we hope to engage in, and hope that you'll be interested in taking this data set and studying it and looking at outcomes as well. So I think with that, I can leave it open to questions unless Jamila have anything to add.
No, that was perfect, Emily. And it's always hard to follow you, so I will decline. But happy to welcome questions. I see one in the Q&A already, so I can look at what that is.
Yeah, so I can read it. The first question is, will the future research compare settlements before and after an eviction is filed in court, since some places have pre-filing mediation?
Yes, where those settlements are entered with the court, that will be part of the study. We are doing random sampling, so it's whatever case file comes up as part of that random sample. And many of them do have pre-filing mediation, and 2 of the jurisdictions have mediation with diversion. So we've included them specifically because of this mediation aspect. We want to see if that intervention without right to counsel has a similar outcome or otherwise. And I should just say, if you were in a jurisdiction where you're looking at the eviction court and you'd like to compare notes or you'd like to talk about different methodology, I think we'd all be eager to have those discussions and see what we can find by the wealth of information that everyone's collecting too.
We have another question. Did you see any changes in courthouse culture or outcomes in jurisdictions where housing law is well established, such as NYC?
Yes, New York City was an interesting place. They had it's a great place to study because it's been around for so long. And because we have so much data, it's a good place for researchers to take a look at the effect of right to counsel over time. In New York City, a lot of our qualitative interviews surfaced initial implementation issues where there were some attempts to divert tenants away from lawyers so that they would settle against their own well-being before they could actually access the court. Today, it's evolved quite a bit, and now their biggest issues tend to be related to having enough attorneys to provide right to counsel to all the people who need it. So that was one of the barriers that we're also seeing in many of the other jurisdictions as well. Jamila, you've spent a lot of time looking at New York City, so I'm sure you have other things to add too.
Yeah, it's interesting. And this question around courtroom culture is a hard thing. I mean, I did a lot of ethnographic work in New York City and spent a lot of time in um, housing courts there in the Bronx, in Queens, in Brooklyn, and then even immediately outside of the city, like in Long Island and so forth. And a couple of different things. One is that the cultures are actually really different in the different courts across the city. So New York City is like not even a single entity, right? It's actually a kind of conglomeration of entities that all have different practices and different constraints. But right to counsel happened to all of them, not at the same time, right? Because it had a staggered rollout, but it happened to all of them. And so, of course, right to counsel is now interacting with these pre-existing cultures, and all of them have to adapt and respond, but they don't necessarily adapt and respond in the same ways, right? And so it's a little bit, it's one of these things that I think in New York City in particular, we try to capture some of this quantitatively, particularly because the rollout was staggered. And that gives us a little bit of additional empirical leverage. And we've seen studies that try to use that, to leverage that, um, to see, okay, what can we learn from the fact that some jurisdictions got it, others didn't? What were the changes pre-post in these kind of staggered timings? And I think that's a really valuable empirical approach. But being in these courts on the ground, there's so much to learn from seeing what happens, right? Um, and it's certainly true that even when I was doing observation in places where right to counsel had been rolled out, I saw tenants in court who were not represented, right? And many of the tenants that I talked to in the interviews didn't know that right to counsel was a thing. Like, even if they lived in a place where it had been rolled out, they were not aware that there was anything even approximating that they could have access to. So I think a considerable constraint in New York City has been um, funding and access to the actual attorneys who can implement right to counsel. It's still done this work on a really large scale, and that is changing things for sure. But it's both an exemplary case because of how innovative New York City has been, and an idiosyncratic case because of the very particular culture of New York City courts and because of the absolute staggering demand for these services.
And on the note of staggering, I will just flag and draw your attention to the data set that New York's rollout was staggered. And in the data set, we capture the dates by the area that was adopted, when it was adopted. And that's similar to a couple other jurisdictions as well. So you can actually see over time the effect of that rollout too.
Yeah, and for any of our researchers looking for some causal leverage, staggered rollouts always give that to you. And it wasn't staggered randomly, like the rollout wasn't randomized, which like as a researcher, like that's your dream because it gives you the most empirical leverage. But as policymakers and as people, the acknowledgement was like attending to things like need and demand. And so it wasn't random, but it was systematic, and so does give that very useful empirical leverage.
Yeah, and there's in the housing policy debate article in the sources, we cite to two studies in New York, one by Bean and Summers and the other by Cassidy and Curie, that really get into some of that cultural effect, that how the system change occurred and what that rollout looked like. So the effects of legal representation on tenant outcomes in housing court. And Stout has also produced quite a lengthy ROI analysis as well. So there's a lot of resources on New York City if you wanted to look at that further.
Yeah. I see another question about whether judges acknowledge that their behavior towards tenants was kind of better in the wake of right to counsel. I want to hear what Emily thinks about that. I will quickly say that I didn't actually participate in any like formal interviews of judges for this research or anything in general, but I did notice with my qualitative work, and I was careful to make sure that I picked some locations for my qualitative research that had right to counsel and others that didn't. And I did notice from my qualitative work, because what I would do is go to a court, usually in the morning when the court opened, and sit in the room and observe. And then at the lunch break, go in the hall and talk to people who I had seen in that court, and then go back in the afternoon and sit in the room and observe again. It was not uncommon at all. It was actually the norm for court officers and even judges to notice that I was there. And I will say, as a Black woman, in many of these courts, I look like somebody who's, especially because I don't dress like I'm a professor, like I'm just sort of dressed like a regular person. And I look like I just belong there because of I'm there because I'm getting evicted. And often I would sort of sit in one spot and people would come next to me and talk to me and tell me things while they were waiting for their, I learned a lot just by being present and looking like someone who people thought belonged there, which I know is based on racism and stereotypes and all sorts of other things. But in this case, gave me some inroads. But often judges and court officers, like when I was back in the afternoon, would be like, "Are you here for a case? Like, why are you here?" And I was very straightforward. I didn't lie to anyone. I would say, I'm a researcher and I'm just here doing research observation. I didn't say, like, I'm from Cornell or anything. I'm tenured. Nothing like that, but very straightforward. And almost always, and I didn't expect this, the judge would say, "Oh, like, do you want to talk to me?" And that wasn't necessarily my plan. But I would say, "I'm happy to talk if you want to talk." And what the vast majority of times judges would pull me aside or sometimes invite me into their chambers and tell me was all the ways they wish they could do things better, all the ways they wish the system allowed them to be better to tenants, all the ways they wish the law was different. And sometimes they would say, like, right to counsel has been good for that reason because it allows them to do more real like work. And so, obviously they're not unbiased about their own perspectives and performance, but they went out of their way to make the case that what was constraining many of them was quote unquote the law or the resources and other kinds of constraints. And it was clear that right to counsel was part of what they seemed to think helped on that front. But again, that wasn't systematic and it wasn't actually part of the research plan. These were just conversations I got pulled into that were initiated by the judges themselves.
Mm-hmm. The interviews of judges are ongoing right now, so we're still coding and analyzing that research. I can tell you anecdotally that I don't think that judges see their behavior as systemic directed, that they are thinking about their role in following the obligations and the judicial canon toward litigants and wanting to make sure that they're applying the law in the way it was written. So if the law says you have to have right to counsel, some judges interpreted that as then I need to give them an opportunity to seek counsel, so they'll postpone the hearing. Others interpreted it as I can't tell tenants about their rights under the law because I'd also need to tell the landlords for it to be equitable. So I think there's certainly a shift. I do think we saw anecdotally, since we haven't finished that analysis yet, certainly a change in understanding that the law was not as cut and dry as it was being presented in the past, that tenants typically had a defense and it was a valid one, that the rent charged was not the rent owed because of habitability issues or because of notice violations or otherwise that the case couldn't go forward. So that bringing that to light, that there was more at question here than what they had understood in the past, really did change, I think, the tenor and the looking at both parties as viable parties in that courtroom. I see there's a question about Tennessee right to counsel and the effect on rental assistance. We didn't study Tennessee. I actually wasn't aware that they had a right to counsel program. So I'd love to follow up offline and we can talk about that in greater detail. There was certainly, I think, a change in eviction outcomes when the federal rental assistance depleted. That rental assistance was a really great way to bring both parties to the table for diversion programs and mediation to keep people housed. And so there are, I think, one thing to just kind of caveat, I don't think any of us on the research team see right to counsel as the silver bullet, the end all be all solution, that the problem is so much bigger than this piece that we're looking at, and that rental assistance is a critical piece of that too. And, during the pandemic, we essentially stopped eviction across the country. We reached all-time historic lows in eviction filings. And when at a time when filings were estimated to be 3 times the typical level, and we never saw that 3 times the typical level come back. We did see eviction filings return to historical averages, but they never surpassed them in the extreme way that we thought they would. So that rental assistance, that access to an advocate, it made a difference during the pandemic, and that's something that we should continue to investigate.
That's right. And I'll quickly just address this question that I see around does current or you know, ongoing research explore how jurisdictions where right to counsel is inhibited by funding, and how people push those initiatives forward. And I will just say that I, in many ways, that shows you where there's an important intersection between right to counsel and organizing and building power in communities and creating powerful coalitions that can make right to counsel possible. So right to counsel isn't an outcome that just emerges out of nowhere, right? And I've done some work on this that shows like actually um, in places like New York City, there were like elite legal communities that wanted right to counsel in various forms for a very, very long time, like 30 to plus years, 40 plus years. But we didn't see it come into fruition until there was a coalition of community-based organizers and organizations that built power and built, um, you know, coalition across groups and that included some of these legal actors and providers, but wasn't limited to them. And that's what pushed some of the kind of leading and most innovative right to counsel programs forward in places like New York City and San Francisco and so on and so forth. I've actually recently just finished building a database that took me 2 years to build of housing and maybe I don't know what I'm going to do with it, but it's not as ready as the database, the policy database that Emily and team that we built. But it's getting close of organizations that do work around housing, whether they're tenant and building power building organizations, legal services organizations or legal organizations, or social services organizations that connect people to social policy benefits that can help them when they face legal problems, things like rental assistance. And what we're using that data for is we're merging with some of this right to counsel data to see, especially since we have the timing, right? To see whether we see right to counsel emerge and whether the way that it's designed, right? More people having access, fewer eligibility restrictions is connected to having powerful organizations on the ground and more rather than fewer of them that can push those kinds of things forward. So I say all this to say, right to counsel is not this floating entity that appears and then expands and is implemented and does its work naturally because it's written in the law or written in policy, right? It is a deep part of political processes. It emerges out of political processes, and its development and implementation is a function of political processes. And that's why we really can't talk about right to counsel. We can't talk about access to justice without talking about and acknowledging power. And that's kind of like, to a hammer, everything is a nail. And I'm a political scientist. I'm a hammer. And that's the nail that I continually bang on. And I'm glad to Emily and others for bearing with me. And so I hope this is not impolite or improper, but I'll put a link to my book that's coming out through Princeton Press. It'll be out in January, but can pre-order now. And it's really thinking about these relationships between access to justice, and that includes right to counsel in a broader array of access to justice related issues as well, and political power. And a big part of the argument that we make is that those things are self-reinforcing and affect one another. So absolutely right, you hit a wall with right to counsel. It's on the books, but it's just not being funded. It's on the books, but you just don't have the attorneys. And what do? If you go back and you just hope out of the kindness of elected officials' hearts, they might give you more money. Sometimes that's possible, but often it's not. And it becomes a question of how power is distributed and whose interests can be and whose demands can be enforced through those power dynamics.
I think that's a perfect note to end on, and I think you've given all of us hammers, Jamila.
Well, thank you so much to our panelists today for talking about this very interesting subject. As I said, the recording will be sent out after this all wraps up. And please visit our website to explore their data set and other law and policy data sets that we have related that maybe you can use together. Thank you so much, Emily and Jamila.
Thank you.
Thanks, everyone.